and then start a conversation. And so you will be in charge, Maria, because you're the discussant, and so you can be the moderator too. Okay.
Okay.
All right. So just for the camera. Welcome everybody, and also the people joining us in TV. Today we have Professor Chiara Giorgetti. She's a very, very well-known professor of international law, and has covered many areas in her research, such as international arbitration, but now she's really involved in the international claims commissions, and has published very interesting papers. And it's today we have a great opportunity. I thank very much our colleague Maria García Casas for her initiative to bring Professor Giorgetti here, Chiara, or may I say Chiara, to our law school. It's a wonderful opportunity to discuss international claims commissions. I from the paper that we have read, we can expect to have insights not only from Ukraine, but also from the history of international claim commissions and its benefits and problems, and its promise as, let's say, instruments of justice with its limitations. And so we're really proud to have you, and welcome to our university to this seminar. This is a seminar that goes on throughout the year for our faculty, and now we are honored and proud to have your name inscribed in it. Welcome, and thank you very much also, Maria, for this opportunity.
Thank you very much. Thank you very much for the very nice and kind introduction, and thank you, Maria, for the invitation, and thank you all for being here. I understand that you may not all be international lawyers, but by the end, you will be.
Instant agreement.
Yes, exactly. So I'm Italian originally, but I've been in the United States for about 20 years. And what I do now, so I'm a professor, but I also am a member of the Register of Claims for Ukraine, which is a claims commission that was established to provide compensation for the people and other actors that suffered because of Russia's aggression. So what I propose to do today is first talk about a little bit just what reparations are in international law, and what claims commissions are, which is a form of reparation. And what are the compensation mechanisms, historical compensation mechanisms that exist, and specifically then the mechanism that exists for Ukraine, and what is the possibility of using this kind of claims commission for other as other compensation mechanism. So please stop him anytime if you have any questions. There's no problem at all. I hope it's a little informal. So please don't hesitate to stop me and ask me for clarification, any questions. Anyway, so why do we talk about claims commissions, or why do we talk about reparations? Because in the Charter of the United Nations, which is essentially for international lawyers very similar to kind of a constitution, right? So the main act, the main act that exists that gives guidance to what the states must do, members of the United Nations. And in Article 2 of the United Nations Charter, there are two very important provisions. One is that says that states, member states, if they have a conflict, if they have a dispute, they have to try and solve that dispute peacefully. And when they say they have to try and resolve the dispute peacefully, to provide also through mediation, through arbitration, or through mechanisms and others. But they also say in Article 2.3 that they should settle their disputes peacefully, such in a manner that international peace and security and justice are not endangered. So you have to do it through peaceful means, so not to endanger the peace and security of the international community, which is the reason why the United Nations are created. And Article 2.4, which probably even non-international lawyers know, especially with everything that's going on with the US, Iran, and Russia, Ukraine, members of the United Nations have said that we do not use, we don't threat or we don't use force against the territorial integrity or political independence of any other state. Unless it is provided for in certain circumstances by Article 51 of the Charter. So in general, there's a prohibition of the use of force unless it is within the United Nations Charter confine. And then there's another important instrument that says that if a state violates international law, and this comes from the Articles on State Responsibility, which I will not go into much detail, this is more for international lawyers, but the Articles on State Responsibility say that if you violate international law, there are consequences. And so every international wrongful act of a state entails certain international responsibility of the state, and the legal consequences are several. One is you have to stop the violation of international law, the breach of international law. You have to continue the duty of performance, so you have to go back and actually perform the obligation that you had. You have to essentially do not breach again, but also you have to provide reparations. You have to provide a certain form of compensation or reparation. And Article 31 of the Articles of State Responsibility provide the reparations come in many forms. So there is an obligation to make full reparation, and full reparation can come either in the form of restitution, compensation, and satisfaction, either singly, which is, I think, a word that only exists there because nobody actually uses singly as a word by itself. But anyway, restitution, compensation, and satisfaction, either by itself or together in combination with others. International law has a preference for restitution, but in real terms, it normally provide compensation for reparation. Restitution means something that, this is for normally for cultural artifacts, for example, that are not destroyed, they're taken, then you bring them back and restitute and give it back, or you're taking gold or something, you give it back. But normally you provide compensation for a breach. And there are many ways to provide compensation. But it is not so, although there is an obligation to provide compensation, how it is actually done in international law is not very simple. In the context of Ukraine, the General Assembly made a finding that Russia's violated international law. There was a breach of international law in the aggression of Ukraine. And so it said, condemned the aggression of Ukraine, finding that there was an aggression, and also found that because of that aggression, in application of the Articles on State Responsibility, then the reparations were due to Ukraine. So how do you obtain reparations? How do you obtain compensation? There are institutions and international organizations and judicial bodies that exist already. One is the International Criminal Court, the European Court of Human Rights, the International Court of Justice. This one is So this is the Peace Palace in The Hague, where the International Court of Justice is situated. The International Criminal Court is also a court of general jurisdiction, to which actually Spain is a signatory and great supporter. And the European Court of Human Rights, of course, you probably know it sits in Strasbourg, but it's an entity not of the European Union, but the Council of Europe, that has also special jurisdiction. Any questions so far? No. Very briefly, just to say that although these mechanisms exist, they have limited jurisdiction. Although the International Court of Justice exists, it doesn't mean that they can hear all the cases or that they have jurisdiction, so they have the ability to provide reparation. The International Court of Justice has limited jurisdiction, which is provided for by each state, essentially, each member state of the International Court of Justice provide the limit of the jurisdiction. And in the context of the Russia-Ukraine example, there's a very limited jurisdiction, which essentially is covered by the Genocide Convention, which is a treaty that both Russia and Ukraine signed. And provided that if there is a breach, then they can, the International Court of Justice can be seized. And Ukraine did go to the International Court of Justice with a big case saying that there was an allegation of genocide under the convention, but this is intrastate, and the International Court of Justice provided preliminary measures, but then also limited its jurisdiction. The International Court of Justice, however, has limited jurisdiction on cases between states only. The International Criminal Court, on the other side, has limited jurisdiction on criminal issues and for individuals only. There is a case pending also in the context of the Ukraine-Russia conflict. Very specifically, though, because the International Court, the Criminal Court, also has limited jurisdiction. And here, 41 member states refer the situation in Ukraine to the prosecutor for specific crimes, and there are at the moment a case pending against the president of Russia and against a minister, but this is limited at the moment for essentially the kidnapping of children from Ukraine to Russia. Finally, the European Court of Human Rights also has jurisdiction for limited cases that also derive from the European Convention on Human Rights. That to say that although there is this duty of reparation, and there are courts and tribunals that exist that are permanent, it is there's very often not a equivalency, so that there are limited provisions, limited jurisdiction of each court, and although there is a duty to provide reparation, those courts that exist cannot very often provide that reparation that is due under international law. This is something that in international law actually is quite common. You have a right, but it's very difficult to have satisfaction or execution of that right. So one possibility that exists under international law is the creation of claims commissions. And claims commissions have been created. And I'm smiling because in looking at this I asked the PowerPoint to provide like a slide and create a slide, and I'm not sure what the symbol in flexible adopt is. Yeah, I don't know. I was looking at it today and I was like, why did they give it two rings? Anyway, but so international claims commissions, why do we create international claims commissions? So if you had the chance to read my short paper, you know the international commissions are not new. So we had many, for example, and I see a map there, between the United States and Mexico, for example, several post-World War I, but mostly in Latin America also. So going back, claims commissions have been used to provide reparations for specific breaches and mostly to individuals. Post-World War II, international claims commissions have been used in very specific situations to provide similar compensation, but not only limited to individuals, but to provide compensation for different categories of actors recognized under international law. So states, individuals, and companies. So international claims commissions are, as the ring shows, are very flexible. You can have one with diamonds or without diamonds. So they're responsive to specific needs, right? They can create, depending on what kind of the conflict is, what the breaches are, you can create them ad hoc and they can be very flexible. And there are dispute resolution mechanisms very often created after a war or after a conflict. They are created under international law, and kind of one of the important characteristics that they have is that they are binding. So they provide compensation under a binding structure, so similar to this international, to the ICJ and the ICC, but they are binding, and they provide compensation for injuries for a variety of claimants and claims. So let me give you a couple of examples. One is the Iran-US Claims Tribunal, the UN Compensation Commission, and Eritrea-Ethiopia Claims Commission. I'll tell you a little bit of each. Now, Maria, I realize that I didn't keep the time, so tell me when I'm. Thank you. As you can see, I can speak for a long time, so please, you have to tell me to stop. So the first example post-World War II was the Iran-US Claims Tribunal. And this is very interesting and actually very timely for now, which I think is quite interesting. So what happened in Iran-US? As you probably know, the Shah, who was very much supported by the United States, was overthrown in the late 70s. And a very different government took power, which was not an ally of the United States. And that created a lot of clash. You probably, I don't know if you've seen the movie Argo.
Yes.
So this is all about that. With the students, also with the Americans being kidnapped. At the same time, all the U.S. interests were confiscated. The United States had a lot of contracts because they supported the Iranian government of the Shah, had a lot of contracts, oil exploration, concessions, armaments. So there were a lot of economic linkages between the two, links between the two that stopped immediately when the new regime came over. And so there was a need to create something to resolve the dispute that were created. And so in 1981, this Declaration of Algiers was adopted, which is very interesting because Iran, the US didn't speak then, and they're not speaking now. And so at the time it was Algeria that negotiated and mediated an agreement between Iran and the United States with the 1981 Algiers Declaration. And the Algiers Declaration provides several things, one of which is the creation of the Iran-US Claims Tribunal, a tribunal that still sits in The Hague, that has jurisdiction for claims from individuals and the state and companies. So Iranians against the United States, right? Because you always have, in international law, it's very important that you have a different nationality. So American nationals against Iran, Iranian nationals against the United States, but also intrastate claims. So claims from Iran against the United States and the United States against Iran. And when I'm talking about nationals, it's both individuals and juridical persons. So it covers both claims by individuals and companies. And so,
can I interrupt with a very
of
basic
course,
question?
yeah, no, absolutely.
International lawyer. I assume the tribunal, the claims tribunals only exist when the states have previously agreed to the creation.
This is very interesting. No, so it was created by this agreement, by the Algiers Declaration.
But the two states are part of this agreement.
Yes. So yes, but it was negotiated by Algeria. So what is interesting is that actually Iran and US, because they were not speaking, they kind of signed an agreement with Algeria to create this treaty. But yes, there's an agreement between states. And this is a very important issue because you have to create a claims commission. Very often ideally you have to have the agreement of the states that are involved. And actually, to go back to this very interesting question, very often claims commissions are created by a bilateral treaty, but not always. So this one was created by these bilateral agreements. And what I think is also interesting is that the Iran-US Claims Tribunal, in the Algiers Declaration, there was also a provision that allowed for the unfreeze, defraud. So when the Shah was overthrown, a lot of the Iranian public funds, state funds, were kept in the United States banks, in the US banks. $12 billion, which by then was a lot of money. I think it's still a lot of money, but now it's not coming for states, it's not as much. And so the United States froze that amount of money, and as part of the agreement, decided to give back 10 billion to Iran, but then keep some for the payment of this commission. And Iran also said that they will, agreed also they will always keep at least $500 million in that fund to provide compensation for the United States nationals. What is interesting, the United States did not have a similar thing, although there are claims against the United States. And in fact, the Iran-US Claims Tribunal still exists, so it's still operating. It's generally very successful, so the relations are still difficult, and now it's very difficult. But until now, they haven't had any conflict. Of course, everything changed about eight weeks ago. Yeah.
And were these commissions generally function primarily for the purpose of compensation, or do they also like incidentally? Because I can see it having like an incidental like truth and reconciliation function, like a transitional.
So there's always, I think, a couple of things. One, so who are the judges in this tribunal? So there are 9 judges. 3 are nominated by the United States, 3 by Iran. And normally the Iranians are Iranian nationals, the US are US nationals. Now there's also a British national. And then there are 3, let's say, neutral. And normally the Iran-US Claims Tribunal does not have a truth and reconciliation function. But there is a relation function because Iran and US still don't have relations. That is kind of an opportunity to discuss things. Right? It's a legal opportunity, a juridical opportunity to provide this, and also to put things on record. Right? So far, all of the awards have been paid by both countries. Iran, because you had the fund, but the United States also, especially for example, contracts of weapons. Now there are counterclaims that have been that are the remaining claims are counterclaims for weapons, like lack of delivery of armaments that had already been bought and paid for by Iran, but were never delivered by the United States. But what is interesting, this is what I say in timely, is that Iran, there's a clause in the Algiers Declaration that said that also says that the United States will not intervene in the internal affairs of Iran. And this is not this provision does not have a temporal end. Whilst the business claims have a temporal end, so they had to be filed by I think by the end of 1982. This obligation that the United States had not to intervene in internal affairs of Iran was like a permanent one. And so, in fact, about 3 days ago, Iran filed a new claim in the Iran-US Claims Tribunal based on the obvious intervention in affairs when the United States began a war or against Iran, I think about 8 weeks ago. And so it's very interesting. This tribunal claims commission that was supposed to be moribund at the end has now become important again. Did you have a question? Questions? Okay, so this is the first, and this is kind of the first revival of claims commissions because claims commissions were not used post-World War II. They were used post-World War I, but not post-World War II. And they were created then again for the Iran-US Claims Tribunal. The second one is the United Nations Compensation Commission. And this is interesting because it's kind of the second model. If the two countries don't agree, then there might be other ways to ensure or oblige or mandate a country to provide compensation. This is not easy though. And in this example, the United Nations Compensation Commission, the UNCC, was created by a resolution of the Security Council under Chapter 7, Resolution 687 on 91. And this relates to Iraq's occupation and invasion of Kuwait. Right? That was a moment in time when the Security Council was actually very active and could provide and create such instruments. So the Security Council created this UNCC, and Iraq did not agree, but it is a Security Council resolution, and the Security Council resolutions are mandatory on all member states. Now, this, of course, is something that cannot be used all the time because you have to have the agreement of the Security Council, and we'll talk about that. But I think even non-international lawyers know that there are some in the Security Council that are more equal than others that have veto power. And so Russia, for example, would veto something similar for Ukraine, or the US would veto something similar for Israel or for Iran. But anyways, what is interesting here that is similar to the Iran-US Claims Tribunal, the UNCC also had jurisdiction over claims by individuals, companies, and states. And what are these claims? Very interestingly, so for example, there were a lot of Asian workers in Kuwait, and they all had to leave and return home. They were displaced and left everything that they had there in Kuwait. So a big number of claims in the UNCC was for claims related to individuals that had to flee Kuwait and had to go back to mostly Asian countries, but also Egypt, India, and others. So you have millions of claims at the UNCC, other claims by individuals. So the UNCC worked by group A, B, C, D, E, and F. And A, B, C were claims of individuals. D and E were claims by companies, and F were claims by states. It was very interesting because I worked on the UNCC, and the firm that I was working with in Geneva represented Iraq. And so in F4 claims, which are larger and complex claims because of environmental damages. And I think one of the big legacy of the UNCC is exactly environmental damages, because the Iraqi would, obviously Iraq is very much a oil-based economy, and so they would burn the oil facilities, and so by doing that they would pollute gravely the air, the land, and the sea. And so all the countries in the region ask for compensation for that damage. And I think also what is interesting is that you have a lot of claims by individuals, a lot of claims by companies, a lot of claims of states, millions of claims of individuals, and the total amount of the claims that were actually paid were billions of dollars. And where did the money come from? In the UNCC, again, because of the Security Council, the UNCC had the Security Council provide for a percentage of the oil that Iraq was selling to go into a fund to compensate the claims. Right? Because of Iraq's situation, essentially the trading and the sale of oil of Iraq was taken over by the Security Council, by the United Nations. And some of the money, some of the revenues was given to the Oil for Food, to provide food for the Iraqis, and a different percentage was put in a compensation fund. So the billions of dollars could be given to the compensation to those that suffered and that were injured by Iraqi's action. And that was from 20% to towards the end about 4%. So this, I think, is a very interesting example, again, for many other reasons, and I'd be happy to talk about this also. But one of the reasons is also how do you process millions of claims by individuals, right? This is very interesting. You can't. You can't read everything. And so this was one of the first ones where actually a lot was done by computer with mass claims processes. And the amount for an individual that, for example, left Kuwait was a set amount once you can provide a statement that the person had to leave. So it was $2,500 for a person and to $10,000 for a family. Questions?
Does recurring to these types of mechanisms preclude the jurisdiction of other courts?
No. I mean, obviously it depends on how you write the instrument. But in general, no. But in the Iran-US Claims Tribunal, there was an agreement, especially by individuals, that this would be the only one. You could go to domestic courts, so there are cases pending on other issues. In general, they're dismissed by the courts. there's no general rules. I think that it's better if you create such an instrument to ensure that all kinds of claims come in. But obviously it depends on how they are written.
I have a comment.
Yeah.
It's interesting because both the Iran U.S. tribunal and these UN Compensation Commission, which you said that both had important degree of compliance with, but both depended not necessarily on the design of the instruments, but on the coercive leverage behind them.
Mhm.
One was Iran wanted their money that was frozen, and in this case, it was the oil,
Absolutely.
Iraq's oil. And so, the geopolitical conditioning of these instruments is the basic
Absolutely. Yeah.
element for them to be
Exactly. And this is maybe one of the criticisms of claims commissions. Why do we have a claims commission for Kuwait, but we don't have a claims commission for Sudan?
Yeah.
And so
or why Eritrea didn't work.
exactly. And so the next example is exactly Eritrea, the Eritrea-Ethiopia Claims Commission, where the awards were never paid, although the awards themselves were modest. The awards themselves, they were not paid. So what is the Eritrea-Ethiopia Claims Commission? And I represented Eritrea in the Eritrea-Ethiopia Claims Commission, but this was also, I don't know why Algeria, but there's another Algeria agreement, because the Algeria mediated a war between Ethiopia and Eritrea. And the war was a terrible war, 1998 to 2000. That was fought in, unfortunately, a very extensive loss of life. And what they say is that it was fought with very new weapons, but in World War I circumstances. So a lot of injured and casualties. And in the peace agreement, there was a provision for the creation of 3 instruments. And the peace agreement was a bilateral treaty. So similar to the Iran-US Claims Tribunal, this was an agreement between the 2 parties. And the 2 parties agreed that they would have a commission that would establish the boundary between Eritrea and Ethiopia. The war was about that. Ethiopia and Eritrea were united by the United Nations after World War II. And Eritrea fought a 30-year war to become independent. Eventually it became independent, I think in 1994. But then there was always a disagreement between where the border between Eritrea and Ethiopia is. You can't see anything, but now it's here, right? If you go in the back, it's here. Right, it's here. I think this is an old one. I don't see, is Eritrea there or is it still Ethiopia?
Yeah,
right? Yeah. And so if you look at this, it means that now Ethiopia doesn't have access to the sea. Because here you have Djibouti and then you have Somalia, but then Eritrea was the part that provided access to the sea from Ethiopia, and now Ethiopia doesn't have access to the sea. So a big deal. And so where the border was one of the issues. And so in the Algeria peace agreement, there was a claims commission, a boundary commission to define where the boundary was, a claims commission to provide compensation, and a third institution, which was never created, that was supposed to decide who essentially violated Article 2.4 of the Charter, who was the one that started the war. But what is interesting here is a claims commission that had jurisdiction, again, over states' claims, individual claims, company claims, although that was not used, but for what kind of claims? Also, it included claims for violation of international humanitarian law, which is the law that applies during war, right? Which is very strange, right? It's unique. So it provided compensation for violations of the 1949 Geneva Conventions and other violation of international law, which is, for example, means war crimes, torture, rape, those horrible things that occurred during war. The Eritrea-Ethiopia Claims Commission did not have a big commission. The UNCC had a lot of commissioners divided into different specialties. So I said A, B, C, D, E, and F. Each letter had commissions attached. The Eritrea Ethiopia Claims Commission only had 5 commissioners, 2 appointed by Eritrea, 2 appointed by Ethiopia, and the president appointed by for an agreement. I hope, no worries, I hope it didn't break. It's done. Sorry. I don't know where's it from. And so they said, actually, they didn't have their own house because Eritrea and Ethiopia both agreed that they wanted to make it as fast as possible and as cheap as possible. So they mandated the commission to resolve all the issues in less than 2 years. So if you compare it with the Iran US Claims Tribunal, it's light speed. But also they didn't want to spend a lot of money on commissioners. They wanted all the money to go to the people. And so they used the Permanent Court of Arbitration to provide registry and secretarial function. And so the awards were essentially, in the big scheme of things, minimal. About 147 million that Eritrea was supposed to give to Ethiopia, and about 126 that Ethiopia was supposed to give to Eritrea. And that is because the Eritrea Ethiopia Claims Commission, in its finding, also said that it was, in fact, Eritrea that had caused the war, and so they had to pay a little more. Okay.
Mm-hmm.
Questions? Are you tired? Shall I go on? Can I go on? Okay. So, in sum, ICCs, what do? They are created in exceptional circumstances and essentially after a war or after an event that causes a lot of damages and is a very significant event. Iran US Claims Tribunal was not created after a war as such, but under a very significant international event. They are necessary to ensure reparations. They're very flexible. The kind of claims, the kind of claimants, their structure is flexible. And they're very feasible under specific circumstances. You have to have an agreement of the parties. There's no alternatives usually. You can't go to the ICJ, you can't go to the ICC. And they very often succeed when funding is available.
Mm-hmm.
Right? So the legacy of the Eritrea Ethiopia Claims Commission, I think, is still important, but the fact that people did not get any compensation is a very important fact that really, and I think, undermines the final success of the Eritrea Ethiopia Claims Commission. And they're politically useful to restore or maintain international peace and security, and very often they're better than any other alternatives to provide compensation. Enters the compensation mechanism for Ukraine.
Can I ask a question about
Absolutely.
the assessment of all the other ones?
Yeah.
Is there a sort of a conclusion about what do these commissions do best? For example, I recall that, well, I read that, for example, in the Iran US tribunal, interstate disputes functions less good, or individual claims functions better than interstate disputes.
Mm-hmm.
So maybe these commissions can do, provided there are funds, can do some things better than others.
Mm-hmm. I think you're right. So there are things that claims commissions can do better than others. I think what is important is that it is clear what you want each commission to do. But I think you're right in terms of providing compensation to individuals. This is something that they can do very well. And I think what is also important to think about is that each commission kind of learns from the previous one. So, for example, in the UNCC decided to give priority to individual claims. And so it first of all decided all of the individual claims, millions of claims, and then it went over to states. But the UNCC, I think, was also successful in these interstate claims, especially on environmental issues.
Mm-hmm.
And what I think the UNCC also did very well was to provide a way to ensure that the money that was spent on the compensation itself. So as a residual mechanism of the UNCC, you have I don't remember the specific name, but it's like an environmental technical committee that reviews the money that was given to UNCC, for example, for restoration process in the sea. And so they will look at, is the money spent, is it successful, and is it restoring the environment in the sea, or is it restoring the environment and cleaning up the sand, right? So I think that's very important. And I think the flexibility, having clear the idea that individuals, I agree, so the Claims Commission should give priority to individuals. I think that can be used between states if it's clear what the function is. And I think they provide compensation to companies also. But I think it's mostly, and then, the fact that it's, they have to adopt mass claims methods to make sure that individuals' claims especially can be heard expeditiously.
So talking about the good sides, right? But also, I guess there were some past mistakes.
Absolutely.
So which ones you as vice chair of this university are thinking about avoiding at all costs from this?
Yeah, so I don't know in general, I don't know how, let's not take it to Ukraine yet, but in terms, for example, of what has been learned. One thing that has been, so UNCC can be very, very successful, and I think you can say it's very successful, but at the same time, it created for Iraq itself, right? So it was very difficult that all of the money from oil, the 20% of the oil for food was taken away. There were a lot of issues also in the delivery, and there were corruption issues also when the United Nations took over the entire revenue, essentially the main revenue stream for Iraq.
Also,
So funding is
due process.
Exactly, due process, exactly.
Because the Iraqis were not present.
Exactly.
In the dispute resolution.
Yeah, yes and no. So my forum, Laliv, represented Iraq. And that's very interesting because, so as I said, UNCC had several claims. All the individuals, Iraq was not present.
Yeah.
ABC, millions, nothing. But there was a division in the, not the statute, but the resolutions that I think was resolution 867, that then kind of gave a little more details and said that some claims should be considered large and complex claims. And in the large and complex claims, then it would be kind of more similar to arbitration. Mm-hmm. So the states made a statement, and then Iraq had a right to reply. And we had some hearings also, limited. But you're right, the due process was not. In the Ethiopia-Eritrea, actually, it was all very much arbitration-like. So they were division of different cases, and then we would go to the commission and plead the different issues. Mm-hmm. But you have to be attentive, of course, about all these issues and due process for both parties, even if it is clear that one is the one that violated international law. Mm-hmm. Did you have a question? No? Any other questions? Shall I go ahead? No. Here. How am I going to time? Okay. Okay, so, and then
you've been interrupting,
but you can. Yeah, I know if your classes and things don't feel bad if you have to.
No, I will let you know. No worries.
Okay, so February 2022, Russia invades Ukraine. This is the second time, as you know, because it already invaded in 2014 in Crimea, but nothing happened after Crimea. In February 2022, however, there was a big cry and said, well, Russia, you are violating Ukraine's sovereignty again. You're violating Article 2.4 again. And what can the international community do? There was a lot of international support for some action, which created some kind of legitimacy, and a history of claims commission. Now, I give you 3 examples, but there are more. There's an example, for example, of Kosovo on real estate, the Swiss banks funds of the Holocaust. These are all examples of claims commissions also. The Ukrainians especially were very adamant that this was such a violation of international law that something had to be done. And they created the president of Ukraine created a commission to look at whether a claims commission was possible. And the idea was, so how do you make sure that if you create a claims commission, It is created with the flexibility that is necessary for the specific case. So what would be the subject matter jurisdiction? What would be the personal jurisdiction? What kind of international instrument? Is there, for example, a possibility of a resolution of the Security Council? No. Why? Because Russia has veto, right? So that example, UNCC, doesn't exist. Is there a possibility of doing a bilateral treaty like the Eritrea-Ethiopia or the Iran-US? No. So what do? So the Ukrainian had to look at something a little different. And also, obviously, the problem of funding. So what did they do, which I think was very interesting? You remember that I told you that although the Security Council did not make any finding that there was a violation of Article 2.4, so the aggression, the General Assembly did. So the United Nations General Assembly said there has been an aggression. This is a violation of international law. All violation of international law have consequences. Among the consequences, so the consequences are, to stop the violation, non-repetition, and cessation. But the other legal consequence is the obligation to provide reparation. And the General Assembly goes that far. The General Assembly says, up to reparation, we are all together. How do we do reparations is very different. And so that was what was very interesting, is that the Council of Europe, which I have to tell my students, but I don't think I have to tell you, is not the European Union. So the Council of Europe was much, much bigger, and until recently, and until the aggression of Russia, actually included Russia too. So decided to pick up that ball that was kind of thrown by the General Assembly. They said, okay, we can do it. We can do it through something called an enlarged and partial agreement. So an agreement that is partial, it doesn't require all of the member states of the Council of Europe, but can also include countries that are not in the Council of Europe. It's a magical trick. It's a wonderful international instrument that the Council of Europe has. And it's not the first time. Obviously, it existed before, but now it used it to create this register. And this register has 44 members, including the European Union. Not all of the member states, again, of the Council of Europe are there. So, for example, Serbia is not there. But members or non-members of the Council of Europe are there. So the United States, Canada, Japan, Australia are part of this register. And the register, the statute, the large partial agreement, says that it is part of a compensation mechanism. And so what does it mean? While before the admissibility, the judgment, the adjudication, and the compensation were all in one instrument, in the compensation, in the UNCC, in the Iran-US Claims Tribunal, in the Eritrea-Ethiopia Claims Commission. For Ukraine, there was a division. We said, first, let's create a register. And the register has a very specific function to only register the claims and ensure that they are eligible. Then you will have a claims commission that will be created, and that will be adjudicate the claims. And then, third part, there will be a compensation fund that will provide the funding, that will provide the compensation itself. The register has composed of the COP, so the General Plenary organ that has all of the member states, so 44 members plus the European Union, a board, and the executive director. The executive director is actually Ukrainian, and there is I wouldn't say it is a big headquarters, but it is headquartered in The Hague. Actually, very close. If anybody's going to The Hague, it's very close to the former Tribunal for Yugoslavia, and very close to Eurojust, which you may have heard of. And then the board, and I'm the privileged to be the vice chair of the board. And the board has 7 members. The chair, Robert Spano, was the president of the European Court of Human Rights. So he knows a lot about the European Court of Human Rights. I'm the vice chair, and then the other members is a member from the United States, a member from Finland, a member from Poland, and then a member from Germany. And they mostly have, so I used to work with Veijo Heiskanen, the member from Finland, in the UNCC. a very big expert in UNCC, and it actually was my boss at the UNCC. And then the member from the United States is Lucy Reed, also somebody who was a commissioner in the Eritrea-Ethiopia Claims Commission. So specialist in Claims Commission, or the member from, and the member from German also was at the UNCC, at the Iran-US Claims Tribunal, and in the Kosovo Claims Commission claims also. The member from Poland is an expert in human rights. She was the agent for Poland in the European Court of Human Rights. And then the seventh is a member from Ukraine, and she is there's a special place in the board for a member for Ukraine. So what is the mandate of the register? I don't know if you can read, maybe. So the idea is to record in a documentary form the evidence and claims information of damage, loss, or injury caused on or after February 24, 2022 in the territory of Ukraine. So the eligibility criteria are three. One is where it happened, so in the recognized territory of Ukraine. When it happened, so after February 24th, 2022, so no Crimea, but anything after February. And then it was caused by Russia's Federation's International Wrongful Act in or against Ukraine. If the board finds that these three elements exist, then we register the claim. And what kind of claim? So some of the things that we've done is the first things that we've done is to create category of claims. And we said there are three classes of claimants: individuals, companies, and the state. And we have given priority to hear and open up categories of claims from individuals. What kind of claims from individuals? Yeah, sorry.
May I ask, how do you handle these claims from individuals that may live now under Russian occupied territory and that might face any sort of retaliation?
Oh, yes, very, very good claim. Very good question. Can I go ahead first and explain this and then tell you? Yeah. So there are 42 categories now that exist. And so there are the one that we opened 16 of them so far, all pertaining to individuals. And the claims from individuals are for either injury of the person, for example, somebody who was tortured or raped or has some other injury to the person, or somebody who had to leave either Ukraine or was displaced internally, so internally or externally displaced, that lost property, immovable property. And we have, or an immediate family member who lost an immediate family member, like the death of an immediate family member. And the claims include also mental pain and anguish as recognized by the European Court of Human Rights. We have received so far about 130,000 claims by individuals, and we have registered 30,000. What does it mean that we register? It means that they fulfill these three elements: when they happened, when, where, and how they happened. You are right. Some of the claims come from the territory, from occupied territory. We have registered so far claims for immovable property that are in occupied territories. The people are not there. The people moved, but they're claiming for immovable property that was there. Mm-hmm. We have not looked at categories of claimants that are still in the occupied territories and are claiming for personal injury. The claims are there are several concerns that we have. One is all of the claims are received and filed electronically. Mm-hmm. So something called DIA, which is a system that exists in Ukraine. And there is one important thing that we were very concerned about is the protection of all the information and the identity of claimants. So we have a system that protects all the data. Mm-hmm. So the identity of claimants is not known to anybody. So there's a very secure system. Yeah.
And given that this mechanism functions under the Council of Europe, how does the jurisdiction question again, how does this work with the potential claims that could fall still within the jurisdiction of the European Court of Human Rights? Like, are they precluded from going to the European Court? Or?
No, but this is another super interesting question. So,
I have a question connected with that, if I may.
Yeah.
Is there a sort of legitimate expectations that you are creating?
Yes. Yes. I mean, yes.
How do you deal with that? Because it could end in
Well, so
nothing.
it could end in nothing, but so I think it puts the more claims we have, the more claims we register, I think the more expectations exist. And so I think maybe it's a self-fulfilling prophecy, right? So you will have more and you will have more expectations.
No, I'll ask later.
Okay. No, then. And so we have to ensure that people know that this is the register, this is the first step.
Mhm.
And so when they fill in the claims and the, is this linked to yours?
No,
No,
it's not. But so,
No, it's okay.
what is it?
No, because all the information, one important thing is that all information in terms of the claims categories or the claims form, everything is available on the website of the register. And the register is called RD4U. I don't know why. And the 4 is the 4, right? So it's not the easiest. But if you Google the Register of Damages for Ukraine, then you can see the categories that have been opened, the categories that are going to be open, and the claims form. So what kind of information we ask for different claimants. We have actually opened up about 2 weeks ago claims by the state of Ukraine also and companies. Claim B1 and C1 for critical infrastructure. We haven't received any from the state yet. If you've received them, the board has not seen them yet. But we expect claims from the state and from companies also. So we are creating expectations, and it's very clear in the claim form that we say this is just the first step of 3. The second step actually exists already. The second step is the International Claims Commission, and there was a treaty that has been signed also under the umbrella of the Council of Europe, also as an EPA, but kind of EPA plus, so an enlarged partial agreement, but also other treaties that exist. But there's a treaty that is now was open for signature in The Hague in December, and has been signed by, I think, 24 countries so far and the European Union, and has been ratified by 3. And under international law, you have to sign and ratify a treaty for that to enter into force. And it will enter into force when 15 countries ratify, and of these 15 countries, they provide sufficient fund also for the creation of the infrastructure. And the Council of Europe thinks that it's possible that this treaty will enter into force, so it's binding, in about 2 years. And this will be a claims commission, and the claims commission will create then, will adjudicate the claims that were registered by the board, by the register. But so some of the lessons, right? So this exists, you create expectations, and the question that you had is very interesting because in the Claims Commission treaty, you have I think it's Article 19 that says that they should try to include claims from other courts and tribunals that are pending. The European Court of Human Rights itself said in a recent case where that,
Yeah.
Oh, okay. So you know the answer. Trick question. Trick question. Okay. Yeah. So the European Court of Human Rights recently said in a case between the 2 states, Ukraine and Russia, that the register exists, and cases where that fall in the temporal jurisdiction of the register there should be an effort to kind of coordinate. Why? Because Russia is not a member of the Council of Europe, so the European Court of Human Rights doesn't have any kind of practical jurisdiction. So they can resolve the case, but they don't have any stake to enforce the cases. So they said, okay, if we don't do it, can the register or the Claims Commission do it? Right? And so in terms of what you said, also one interesting thing is the Register of Damages actually take example or is modeled after another Register of Damages that exists, and it's called UNROD. And this Register of Damages, which is not very well known, is the United Nations Register of Damages that was created after the International Court of Justice advisory opinion on the legal consequences of Israel's construction of the wall on Palestine's territory. And so the ICJ says, well, Israel, you are creating this wall, and you are violating international law. When you create this wall, for example, you are into Palestinian property, you are dividing. The big thing is agricultural claims and olive trees. And so the court says, well, you have to create this register of damages that looks into, that actually has a very similar mandate as the register of damages for Ukraine, to look at in a documentary form of registration of claims. The UNRWA, however, stops there, doesn't have any idea that maybe there will be a commission. It says, we register so far, it's 3 members, it sits in Vienna. But what I think is interesting, because the register for Ukraine look at UNRWA, and then UNRWA look at the register for Ukraine, because recently in a resolution by the General Assembly said, well, we should look into what has been done by Ukraine and try to do something similar for Palestine, for UNRWA. And so this model, which I think is quite interesting, so the ICJ said, well, let's look also, and the General Assembly said, okay, let's look at this model where we have a claims commission, that is kind of divided, and we can look at it for Palestine, but we can maybe also look for climate change. When we look at climate change, the ICJ also looked at, in the advisory opinion, looked at climate change, and Judge Tladi from South Africa wrote in his opinion, not dissenting, separate opinion, said maybe we should look at claims commission to provide reparation to individuals that have suffered because of climate change, people that are displaced, people that cannot use the land anymore because of desertification or because of deforestation. The third part, yes.
Connection with climate change. Are you aware if these ideas of creating a commission on claims on climate change are linked to the fund of loss and damages already created within the UN, the Framework Convention on Climate Change?
Oh, that's a very interesting question. So the fund, as far as I know, has very little funds. Right? The fund itself has very little fund.
Yeah.
Right. So countries promised, but they didn't put any money on it. So I represented the African Union in the advisory opinion, and I, because I love claims compensation, actually. So we argued. We said we should try and use these models that exist, because these models have the possibility of providing compensation to a lot of individuals expeditiously. And so you should look into this. Court, you should look into this for climate change also. So the court knows about that. I think the fund was created separately, but it's possible to use that. Yeah. Other ways to fund the fund for climate change would be, for example, to ask polluters to put a little money every time they kind of pollute. There's a system for oil pollution in the sea, where I think it is the owners of the different ship that the shippers, whatever they call, the Onassis of the world, have to pay some money into this fund, the oil pollution fund. So there are examples of kind of creative, innovative thinking. And I know you have a question about funds.
Yeah.
But do you have a question?
I have a question, but I'll be at the end.
Yeah, I think we're at the end.
Concerning climate change.
Unless you want me to speak, I can speak for you.
Okay, I'll ask.
Okay.
I'll go ahead. Thank you. I wanted to, well, it was related more to the issue that was being commented before. I think these mechanisms are amazing, and I think they are brilliant initiatives, by the way. And on the other hand, I just wanted to ask, I have read your paper, and I wanted to ask you a question on whether the claims that are received by the register rely mainly on voluntary submissions. Because if they rely on voluntary submissions, or whether you have people on the ground working on these submissions that are being sent, because there are crimes that are normally easier to communicate and crimes that aren't.
Mhm.
And some that are more likely to be reported than others.
Mhm.
For example, sexual violence is one that's normally always carries stigma
Mhm.
and embarrassment. So I just wanted to know on how the register works in relation to these claims and whether it's mainly voluntary
So yes,
or not. Thank you.
it is completely voluntary.
Then
The
it's a gender, then it would be made, sorry to interrupt, it might be, for example, it might be a situation where it becomes a gender blind claims commission, in the
what
sense
do you mean
of,
by gender blind?
if it's only voluntary, then there won't be some crimes being investigated on or being.
We don't investigate.
No, filtered, I mean,
So the different categories. If you look at the different categories,
received, I meant.
Right.
Mhm.
so you mean that the claimants.
And categorized.
So the categories are there.
Mhm.
So there are categories, and they provide. So as I said, there are crimes against so injury to the person, but then injury to property. Injury to the person are very different categories, including torture and including sexual crimes, and including and one that says other crimes, because maybe we didn't think about anything else, and so they're the kind of catch-all final category. So sexual crimes are there. And I don't know if I understand what you mean by voluntary. Voluntary means that, yes, we're not looking for, we don't go and say, well, you have to file a claim. But we ensure two things, and this is more the,
I mean, in the sense, sorry, in Rwanda, for example, many women didn't come out with the crimes. They needed help from civil society to be able to bring evidence to the tribunal. So what I'm saying, I'm referring more to that kind of.
right, so yes, so it's not
basis.
voluntary, that the sense it's not a government does it for you. But we do have, so this is,
NGOs, for example.
so we have dissemination, a lot of dissemination. So we do have an office, the register has an office in Ukraine, in Kyiv, and there are a lot of, so the idea is to let people know that this register exists, and that if you need help filing the claims, they can help. But also there's a lot of contact, both in Ukraine and outside Ukraine, trying to reach out people. And you can't force anybody to file claims, but you want to make sure that people know that they have the chance to do it.
But there's there's a gap in between, in the sense of there are some types of crimes that
Of course, so let me,
need some backing, not only, it's needs some backing, which goes beyond, which is not forcing, but not being completely voluntary, like saying that these claims are being heard and that it's open and that they can send them, but some kind of support. That's what I'm trying to
Yes.
say.
So we have connections. So the office in Ukraine disseminates and has a lot of contact with civil society, including civil society that look at victims of sexual crime. And there are two things I think are important. One is that you look at what kind of evidence we require. In terms of sexual violence, for example, we are very concerned. We don't want to re-traumatize the person. For sexual crimes, is also for torture. So it is very difficult for people to say again what happened to them. So we really ask for very minimal evidence. And the second, I think the approach in general, so possibly a medical certificate, but some people don't want a medical certificate, they don't want to go to the doctor, they don't have a medical certificate, and that's fine. So we rely on a statement by the person, and we don't ask details. The second is we adopt something that's called a victim-centered approach. So we are very sensitive to all these issues that you're mentioning. So we don't want to re-traumatize the person, but we want to ensure that the person is able to come and file a claim. You're welcome. That said, if you look at the categories, it is true that we have not received a lot of claims. And so I think one of the issues is, exactly. So we are looking, and we want to make sure that people know the victim approach, the fact that we don't require a lot of evidence. But I think it is difficult for people to come. If you look at the categories, we have received a lot of the main categories for claimants for us. One is immovable property. Right? That's easy. the Ukrainians require also, if there is a damage to an immovable property, there's a data, there's some recording from the Ukrainian authorities themselves, and so we can verify with that. At the same time, also a record of death. We have a lot of immediate family members that request, a compensation for somebody who died in the family. There is a record for that. And we also have a lot of claims actually from occupied territories, for immovable properties from occupied territories. We don't have a lot of claims for injury to the person.
Mhm.
But we're trying to make sure, because we know that unfortunately these things happen. Yeah.
Yes, I have a more political question.
Yes.
That is, taking consideration the context, especially the changing role of the United States. For example, do you think that it can happen that, being or trying to be doing the mediation in this conflict, that they can force, for example, agreements that just avoid after this work of these commissions, etc. So especially they are criticizing everything that comes from these international institutions. Do you think that this can really have an impact after that, or that we are in a moment where nothing can happen and these things can just...
I think we are in a difficult moment, right? No, yeah.
You say that some of the commissions didn't work so well, and also it depends on financing.
Yeah, so a couple of things there. One, and I do want to spend a little time, if you indulge me later, about where do we get the money, because obviously the Eritrea-Ethiopia example says that we do really have to get the money. But in terms of the political strategy, I think you're right. It is a delicate moment, and I think it is important to take into consideration how it has changed. Now, the United States, together with the negotiation of the register, there's been another negotiations for the creation of a tribunal of aggression, against for the crimes of aggression by Russia in Ukraine. That's been negotiated. And essentially, these two instruments have been negotiated in parallel. The United States have been very involved in both, but have decided not to ratify or sign the Tribunal for Aggression, but it continues to be involved in the register. So it's paid. Every member state has to pay a certain amount, and is up to has paid all the things that are required. And it's possible also because this is essentially a civil compensation. It's not a criminal issue, and so I think it might be easy. That said, because we know about compensation, Iran now is saying, well, we have to provide compensation, reparation to us because of what you've done. And so if you recall, maybe about 4 weeks ago, the Iranians started charge like a $1 million for every shipment that goes through the Strait of Hormuz, and that money is for reparation. Right? So the Iranians said, we're using this for reparation. Oman, which is on the other side of the Strait of Hormuz, also got the $1 million. I'm not sure why they have reparation, but and the countries in the region, so the UAE, Saudi Arabia, and Qatar, have all said, well, Iran, you have to give us reparation because you have bombed us and we haven't really done much, right? And And so I think this idea of reparation is something that is becoming at the forefront of international law and the international negotiations also. And how will that influence? I think the United States will say we will never pay compensation, right? But at the same time, Israel is saying we'll never pay compensation to Gaza. But there is a lot of pressure for that also. But I think the idea that at least we're talking about all this kind of compensation and reparation for these crimes, for this injury, I think is important. And I don't see so far. I think it will be very difficult really impossible. The United States will not provide reparation as such to Iran, but they might find some other ways not to call it, compensation or reparation, but still do it. Can I just say to you, because I know that you're interested on this question of crimes for So if you look at the website of the register, there's a specific, all of this thing about this victim approach, and explain specifically what we do and how we take that into very serious consideration.
Yeah, thank you very much for your enlightening presentation. I have a question. I'm sorry, maybe it's too basic, or maybe I missed the information at the very beginning.
No,
because I was late.
no, sorry, no, never.
Is, if I understood correctly, the International Claims Commission, the examples you put at the beginning, seem to be based on a reciprocal nature of the compensation. So at least the Iran-US Claims Commission was, both countries were compensating the others, individuals and companies. But this register of damages for Ukraine is only based on wrongful acts by Russia. I'm not questioning who is the aggressor here, but my question relates on the mandate itself. This is not reciprocal then, and so who is qualifying what a wrongful act is? I mean, in the case of the bilateral claims commission, there was an agreement by two countries.
Yeah.
On the UNCC, it was the Security Council saying this is the basis.
Yeah.
What is that basis?
Right. Now, this is a very important question. So it's not always been reciprocal. In the UNCC, Iraq didn't get anything. And why? Because Iraq was the aggressor. Was a recognition that Iraq was the aggressor. Did Iraq suffer damages? Yes. Did the individuals, Iraqis, suffer damages? Yes, and it's very unfortunate, it's unfair that they didn't get anything. But the instrument was created because of Iraq's aggression on Kuwait. And this is similar to what's happening for Ukraine. The mandate is very limited to only to injuries that were caused by Russia's attack into Ukraine, in the territory of Ukraine. And yes, they've been dead by Russians also. And actually, one of the decisions that the register took was not to have claims, not to allow claims by Russian nationals. Why? Because in the violation of international law, the norm is that Russian nationals would have a remedy within Russia in itself. It's not an international remedy; it would be a national remedy. But you're right. Well, so some claims commissions are reciprocal and some are not.
Do you know if there was any discussion on establishing a reparation commission for the 2003 attack on Iraq?
There hasn't
we had
claims commission, no.
There's no reciprocity there.
No. But so that's the thing, right? So United States, so Iraq, but even before Iran, in February, what was it? The first, I think, airplane.
I have a question on funding, which is there's from the point of law. I'm here thinking as a strict lawyer.
Mm-hmm.
So there's an original sin or a problem when one country freezes the money of another country just because it decides it's fair. But isn't that basically illegal under international law?
Yeah, this is a very important question. So for the non-international lawyers here, one of the issues, so Russia has violated international law, right? And so a lot of countries have said, okay, so now we have sanctions and we have a lot of funds because Russia has had a lot of funds around the world. Mm-hmm. And if you look at the membership of the register, you will see there's a mirroring of where the funds are, right? So a lot of funds in Japan, a lot of funds in Canada, some funds in the United States. Most of the Russian sovereign funds are in Belgium. And so all of these, so far, they're about, I think, over $300 billion of funds, sovereign funds that are frozen in different banks. And one of the proposals was, well, why don't we use these funds, similar to the Iran-US Claims Tribunal, to pay compensation? I think under international law, actually, it's not an issue. I don't think it's a very problematic issue. I think because of the Articles on State Responsibility, it's a violation of international law. And so there is a duty of reparation. And this duty of reparation at the moment is essentially taken over by the international community until Russia does it. And frankly, I also don't think there's a big difference between freezing and seizing. Because if you accept that freezing is legal, then maybe seizing is legal in the same way. So with adopting this idea of countermeasures.
I'm not sure I agree with you because
I know it's not. I know it's
No.
not a
It's not
majority
peaceful.
view.
Yeah. No, it's not a peaceful issue. I mean, a lot of people are saying this are countermeasures against those who propose this seizing of assets as countermeasure. They consider that they are redirecting. At first, they were freezing the assets because they were trying to compel Russia to comply with international law to cease the aggression, and now they are seizing the assets because they are trying to they are trying Russia to pay reparations, and until Russia does, they are doing
Those
it.
are two different things.
No, definitely, but I am saying what the proposal goes,
Yeah.
the argument is, but of course it's not peaceful.
Yeah,
So-
but the legality of in the first case is easier to sustain
Yes.
because the countermeasures are really directed to ending or putting an end to the wrongful act. And well, it depends on
Yeah,
how
but
you understand the wrongful act. If
Yeah.
you said that that involves reparation, of course, but then again, when the U.S. froze Iraq's
Iran's funds.
Iran's monies. Well, I remember that they froze almost everything, almost everything, and I really thought that was illegal. When I read what I mean, it was really arbitrary, in the sense that every asset from Iran or citizen from Iran was frozen immediately. And we had some experience with that with the Cali case. And in Europe,
No, absolutely. Yeah, of course.
I mean, you have to follow some rules.
Yeah, no, absolutely.
And-
Absolutely.
and it's-
Absolutely.
And it would apply the same rule to the Russian assets.
Yes, definitely.
Yeah, I think what is interesting actually, so for the funds, so how do you find the money? You know, if you go through this and you create the expectations that the people that file will get some money, where do you find the money? And there are different alternatives. I think this idea of using the frozen funds is one. The idea of using the frozen funds as a stick, right? So because eventually in the Iran-US Claims Tribunal, the funds were not the frozen funds. And they were the funds were given back to Iran, but there was an agreement to keep some. And because Iran was also now going into war with Iraq, so they needed the fund. But so using as a stick and then hoping that Russia will come. What is also being done at the moment is that you have this kind of exceptional interest that had been accrued at Eurojust, and so they're using this amount. So it is not using the frozen funds, but is using unexpected interest, and they're now given as I think collateral for debt relief. The other possibility, which has been discussed, is also to possibly use, similar to the UNCC, use a percentage of the oil, right? So charge the oil that is used a little bit, and then use that money to create a fund. So I think there are different ways. I think you're right. The use of frozen funds is the one that's been discussed for a long time, but there are also other ways that could exist. I think the idea is you want to have funds. I actually think that the seizing funds is not unproblematic, but is in terms of countermeasures, meaning you have to do it with the idea that you kind of urge the counterpart to pay and provide restitutions and essentially to fulfill its obligation of international law. It has to be fungible, and I think money is fungible. You have to be returned, and then until Russia complies. Right? So I think there are different ways in which you can safeguard and make sure that international law is respected. And I think the idea of countermeasures, essentially, what is that you suspend? What are the countermeasures? Allow the suspensions of certain international law obligations until the underlying obligation is fulfilled. And there is the obligation of immunity of the funds. Right? It's not anything else, it's the immunity of the funds.
That's interesting. I guess that it also depends on how do you see the whole scheme or the whole architecture of the instrument and Because the way you put it, it would look like a sort of post-conflict mechanism of justice,
Mhm.
which is very appealing, but it also creates the idea that you perhaps want to solve more issues that you really can't do in the end.
Mhm.
It's a
Yeah, I think it's interesting. I mean, can we use it more? I think probably we could use it more. I think it's a little, as I said before, it is a little unequal that you create it for certain conflicts but not for others.
May I,
Yeah.
may I do, may I intervene to, as a sort of moderator and give the floor to Maria
But
to say a couple of things.
I don't think
before
anything I
ending.
might say it's relevant compared to the conversation you are all having. So I'm happy if I'm.
I don't believe you.
Okay, no, what I was, thank you very much, Carlos. What I was planning on asking Professor Giorgetti about that is especially about the funding, which is closely connected with the first question you asked, Luis, and it was because the problem, so to speak, that I see here is that with this international claims commissions for the Commission for Ukraine, we don't have, of course, a bilateral agreement. Either we have some kind of authority, such as a UN Security Council resolution. So that's why we have now the problem of who's going to pay for this compensation, because I don't think it's. There is no way to make Russia pay for that. I mean, of course, Russia has to, and the primary and the secondary norms already exist. So the mechanism is not creating the rules, but mechanism, I think, lacks authority because it is created by only states who are not the responsible state. In general, I mean, I've been looking since I'm a firmly believer of justice and reparation shall be made. I've been looking at it from a very optimistic way. So, and of course, I find that it always happens that for me, this mechanism lacks this. I don't know, this last piece of the puzzle, which is how can we go from the existence of the internationally wrongful act, the obligation to pay reparations to the victims, and then the enforcement of that. And when the convention was adopted in last December, I was following the negotiations, so I already knew that the convention foresees Russia to be a part of this convention. Mm-hmm. It is expressly foreseen in the text. So the idea is like, to my mind, it was like the International Claims Commission for Ukraine wants to be inside the scheme of the Articles of State Responsibility of states, that. Ultimately, if we consider, as I do, an utopian scenario, the one of Russia becoming a part of that convention and paying for the reparations due, I think we have the problem, of course, of funding. So the third element of the compensation mechanism, this compensation fund, could be also something utopian. And what happens with the proposals for using the assets to fund this compensation? I mean, for me, it's doubtful, but I think if you consider, I think that the starting point is that you consider that there is an obligation of a state's obligation to pay reparations to victims of human rights violation or grave breaches of international humanitarian law. That wrongful act, the failure to comply with that obligation, is what allows the other states to use your funds as countermeasure, because while you're not fulfilling that obligation, I am doing it by seizing your funds. And it's a fungible good, no, asset. So, I mean, I think it could, I think it works, or it may work if we want to comply with the Articles of International Responsibility of States. The second problem we have is the immunity of those assets, and for me this is a problem. Is a bigger problem than the one of the countermeasures or the legality of the countermeasures, because if we are talking about the Central Bank of Russia assets in Belgium, for example. I mean, I explain to my students every year that those goods, those state goods, are immune for any executive or so. The problem would be for me if not the countermeasure in itself, but the problem of whose assets are we seizing. And for example, and I'm going to end with this because I mean the conversation was going very, very well, so I don't need to add anything else. But the Central Bank of Russia has recently filed an action for annulment against the EU Council decision on prolonging the freeze, not seizing, but I mean the prolonging the freeze in that EU Council decision means seizing on the CBR's European assets indefinitely. So, seizing. And the Central Bank of Russia has alleged violations of fundamental rights and violations of public international law, namely the provisions of state immunity. And for me, when I read that, when I knew of that, I remember Cadi, and I remember so many others, precisely with if I don't remember wrong, the Iran Central Bank also that went to the also claimed the illegality of this kind of seizures or prolonging freezing of assets. So what I think would be the most difficult issue to overcome to fund this compensation fund, and so to effectively pay compensation for victims, could be the immunity of this, the state immunity of the assets. I don't know if you...
Oh, can I ask you a question to both of you? Because,
No.
the problem for me is the slippery slope of these kind of decisions. Because, I mean, you start with Iran in the 90s or in the late 80s. The late 70s and the early 80s. And then you freeze all the Venezuelan assets just because you don't like, I mean, you're against the regime. So, I mean, what's legal here? Where did you put the limit on it? And because there is a slippery slope. And the United States has almost all the world sanctioned. I mean, if you look at the sanctions of the United States, they sanction, unilateral sanctions throughout the whole world. So I think that we must have some kind of limits to that also.
No.
I agree.
Okay.
I think you have to have some limits, but I think you raise a very important issue with the Claims Commission pointing out that ideally Russia will join. Right. So everything is, the idea is that Russia at one point will join. The war will end. This is one thing, is that this process has started before the end of the conflict. All the others that we mentioned, they started after the conflict. So it was clear who was the winner, and it was clear what the positions were. This is the first one, but the conflict is still on. But the idea is always that Russia, hopefully at one point, they will join, and then there will be some negotiations, how they will join, what their role will be. But the idea is hopefully they will join, and so maybe Iran-US Claims Tribunal model, that it will be frozen, right? All this 400 billion, some will be given to the claims, the compensation fund, some and some will not. But I think the issue of sanctions is a very important one. What are the limits? And I think you raised a very good point. I think under international law, you may be able to do more sanctions that the political asked by the political parties is willing to do. And obviously for the Iran also there are the cases at the ICJ that says certain limits you cannot that are illegal under the treaty. Sorry, yeah.
Yeah, regarding the limits and where do we put the red line, I think it's important to acknowledge that regarding this conflict, we have an UN Assembly resolution really backed from a lot of states saying that Russia has committed an aggression.
Right.
And that's something that, for example,
And that's a
doesn't exist
recommendation.
in-
Yeah. So I mean to
Yeah.
look back, yeah.
I mean, you don't have the Security Council of
I
Litigation.
know, but there are all states voting in favor.
Yeah, but
And for
I
me,
can
that's
mention
some kind of
dozens.
legitimation.
Dozens of General
And you
Assembly
have that
resolutions that
So if
are-
I
Have that
mean, yeah.
Iran and Venezuela.
But for David's looking at David's argument, you're completely right. The General Assembly resolutions are fantastic, but they're not binding. They're not general, they're not
Yeah,
General
but
Security
this-
Council.
this,
Obviously, this one was was widely supported and everything, but so you can argue both ways. And I think on sanctions, we have this idea of now doing smart sanctions. You have to make sure that you're not hurting people, that you are. So this is very important also. But I think it's a very important question. What are the limits of
Yes,
sanctions?
yes.
And do we want sanctions to be only international? So it is either through the United Nations or the European Union and not
Mhm.
by one state blocking everybody else.
One issue that I think that's important here is that it might end up being a sort of Iran US situation here, because Russia might want to recover some of the assets that are freed, and maybe they can in the end agree to some of them being separated for compensation goals.
Exactly. And I think another important issue is that here we're talking about sovereign
But
funds.
that would be negotiation. That would be illegal.
Yeah, and sovereign funds, you're right, but there's also the sanctions on individuals.
Mhm.
And when I go to Italy, you have this huge yacht that is,
Yes.
is
Example. Some of
yeah,
them are being
auctioned.
not only auctioned. I mean, the cost of
The costs are enormous, exactly.
Are being
Exactly.
I think paid by Italy itself.
Yeah, yes, exactly. So Italy
it's costing them.
no, but so it's enormous and it's in Trieste. So you'll see it's enormous, it's beautiful, but you have to sell it every now and then because it can't just stop there. And so you have all these frozen funds of individuals, and so I think for sanctions is a little more complicated. Are oligarchs the same as the state? No, but what are the sanctions? How do you can you pierce the veil? But yeah, it is. I mean, there's a lot of interesting work to be done on sanctions. Sorry.
No, I don't want to.
Okay. Do you want to final word or we go?
Your final word.
My final word is, of course, to thank you. Thank you very much for being here. It's been delightful, at least for me. It's really thought-provoking, and we're really grateful to have you here. So I would like to thank the Anuario de la Facultad de Derecho por organizar este seminario, a Carlos, a Carla. Muchísimas gracias, y a todos los demás que habéis asistido y que además habéis participado de esta forma tan viva, que lo ha hecho
That's a
súper
great
interesante.
conversation.
Yeah.
Thank you very, very
Thank
much.
you. Thank you
We
very much
learned
for
a lot.
engaging all the questions. Super.
It was great. Yeah.
Do we have people on this?
I'm not sure. We didn't give the floor to them.
I forgot.
Yeah, I totally forgot. I'm sorry. No sé si había alguien conectado al que tuviéramos que haber dado paso, pero te hubiera llegado alguna notificación.
Sorry, I didn't want to say volunteer. Like, I didn't want to coerce. I said voluntary in the sense of having someone there to help victims send claims.
Yeah.
I was like a bit tense. I didn't know.